we're here online, and Rich and I were just having this discussion. And for anybody that heard, it's so uncomfortable to do these Zooms. I like to be in person. I like to walk around a room. I like to see people's faces. I can't see your face. All I can see is my computer screen. So it takes a lot of getting used to, and I'm still not used to it. But I do the best I can. But I hope everybody's doing well, and I hope you're enjoying the holiday season. And hopefully, we can get through this in the time that's allotted. I do appreciate questions. So I have the Q&A screen open over here, and I will do my best to answer questions to the extent that I think they're relevant and that they're going to provide further insight to those that are listening. So I have that over here. I am going to talk to you in general terms, obviously, because this is very technical, about ways to protect the homestead, or at least topics that you should be aware of, techniques that you should be aware of. I'm assuming, and perhaps I shouldn't do this, but I'm assuming that most people, or many people that are on this Zoom call, are practicing the area of real estate, and I find that there are so many issues that real estate attorneys are confronted with on a regular basis, just by virtue of just being around the real estate process on a regular basis. So I get calls very often from real estate attorneys asking about trust and life estates and should we transfer the house to the kids, and what are the consequences of considering all these different types of techniques. The unique thing about all of this is that there's an element of estate planning, there's an element of real estate law, real property law, but there's also a strong tax element that goes through all of this. And I happen to be an accountant as well as an elder law estate planning attorney, so I find it intriguing to be able to assess each one of the planning techniques that we're going to be talking about today. So you've got to be careful. You're going to see when we go through some of these slides I prepared, you just don't want to, operate willy-nilly or kind of, knee-jerk reaction, especially if a client comes into you and says, hey, I want to give my property to my kids. Just, you got to pause for a moment. You have to think about the consequences of doing something like that. Maybe you have a relationship with me or somebody else like me. It's always a good idea to reach out to an elder law attorney. So the first slide that I have over here is just to kind of take us kind of back to the beginning. Like, why do we even care about all this? Why does this field of elder law exist? Why is our bread and butter protecting the homestead? Why should almost every single person out there be thinking about this? Well, the conversation usually comes up when a client comes to the office and says, hey, listen, what happens if I get sick someday? And I say to the client, listen, if you get sick someday, or, sometimes I turn it around, I say, can we agree that you may get sick someday? And they'll say, yeah, I guess we can agree to that. And I'll say, well, if you can agree that we might get sick someday, can you agree that you might end up in a nursing home? And of course, nobody wants to hear about this. You use the word nursing home, and people sometimes they clam up and they shut, especially the Italians, by the way. My family, if I would talk to my father, my grandparents, when they were alive about a nursing home, I'd probably, it was almost like I should be kicked out of the family. But nobody wants to talk about these things. And I say to the person or the couple or whoever it is, the family, I say, listen, if you get sick and if you go into the nursing home, there's very limited ways to pay for the cost of your care. And in fact, there are only 4 ways to pay for the cost of your care. You could pay for it yourself, which is very expensive. A lot of people don't realize that the cost of a nursing home is, in this area, about $18,000 a month, $15,000 to $18,000 a month. And that varies, but that's option 1. Option 2 is long-term care insurance. And maybe you have long-term care insurance, but a lot of people don't have it. It's expensive. Some people can't get it, maybe because of an existing medical condition. And years ago, if somebody had long-term care insurance, I would say to them, listen, you're good. You don't need to do any more planning. You've got long-term care insurance. But now, because of the cost of care in our society today, it's very possible that somebody can run out of their long-term care insurance. If you end up with a cognitive illness or cognitive impairment, and you're in a nursing home for an extended period of time, you could run out of long-term care insurance. The third option is Medicare. Medicare, only pays for about 100 days in a nursing home, and then you're on your own. And the last option is Medicaid. So if you kind of follow that quadrant that I just created in my head, you start to see that long-term care insurance is probably not an option for many, although I do tell people they should consider it, and it has its place. And Medicare is limited. So if you haven't done any planning, you're most likely going to be privately paying for the cost of your care. If you met with somebody like me or another elder attorney, and you talked about Medicaid planning, that's going to be one of your major options as the payer of last resort, if you would. And that's how we get into talking about trying to protect your assets, because the majority of people out there today, Medicaid has in essence become the insurance of the middle class, right? If somebody goes into a nursing home, those are the 4 ways that you're going to pay for your nursing home. And I'm talking about nursing home care because it's harder to get into a nursing home than it is for home care purposes, right? Or should I say, the Medicaid rules are more stringent in a nursing home context. And that's a lecture for another day. We're not going to get into Medicaid eligibility, but it's harder to get in to become eligible under Medicaid for a nursing home scenario than it is for home care. Right now, and the laws may change on this, we're not getting into that today, but the laws may change. But right now, you can transfer your assets and you can apply for community Medicaid the next day. There's no 5-year look back period, and that might change, right? And that's all I want to say about that. So that's how this comes up. And when we continue the discussion, and hopefully the people that I'm speaking to say, all right, I get it. So now what, Sal? And we go through their assets, and there are different rules for different assets. But generally what kind of, fizzles to the surface is the house. And, in many cases, the house might be the largest asset. Somebody might have purchased a house years and years ago, let's say in the 60s or the 70s for, $25,000, and now it's worth $750,000 or more. And that house is, the primary asset, between whether it's a single person or a couple, and everybody wants to try to preserve their homestead and try to get it to pass on to the next generation. So let's go to the general rules about, a homestead. So the first thing, which I think is really neat and very important, is, what is a homestead, right? And you'll see on my first slide, it's obviously, the primary residence. When I use the word applicant, I'm talking about Medicaid applicants, right? So it's, if we were to apply for Medicaid, Medicaid says, okay, the homestead is your primary residence, right? Interesting though, it's not just limited to your house on Elm Street, right? It could be a vacation home. I'm sorry, it could be a condominium. It could be a co-op. Uniquely, and I've done this before, a mobile home, right? A lot of people have downsized and have purchased mobile homes, and that's considered primary residence, right? And it also includes the contiguous property, right? So sometimes you'll see a house on one deed and the lot next door on a separate deed, and there are special rules for that, right? So as real estate attorneys, you want to pay attention to some of this, right? Because, if somebody is looking to protect their homestead, you want to make sure that you're getting the maximum protection as possible. But it doesn't include the secondary residence, the vacation home, the summer home, the cabin upstate, the hunting lodge. It doesn't include that. And for those reasons, not those reasons alone, but we're setting up, we're implementing some of the planning techniques that we're about to talk about, because a lot of people don't only have a personal residence, they also have, a second piece of property someplace. If somebody, I'll try to remember, but if somebody, says to me later on, Sal, remind us about co-ops. Rich was mentioning co-ops before, and I just, I think it's important to mention some of the I'm not going to say pitfalls, but some of the obstacles that you may encounter with co-ops. Co-ops could put a monkey wrench in the plan. So you've got this primary residence that Medicaid defines as your homestead. And the question is, well, how does Medicaid treat it? So if I had to apply for Medicaid, how does Medicaid treat my homestead? Well, it's exempt, generally speaking, right? It's exempt if you're living there, and it's, they use the words essential and appropriate. But for the most part, your primary residence, if you're living there, it's an exempt asset. If your spouse is living there, it's an exempt asset. But we've got this rule in New York State. We've got this home equity limitation, and it's started out at a much lower number, but it's been going up every year. And for 2023, the number was just over $1 million. And you have to be careful, right? Because and I admittedly, I think sometimes I even lose sight of this. Somebody comes in, they sit down, they say, "Sal, I want to protect my house, or my aunt needs Medicaid." Okay, fine, the house is an exempt asset. Hold on, we got to be careful. Let's find out how much that house is worth, especially in this area. I'm in Rye right now, but all of Lower Westchester for the most part, and Northern Westchester as well, all of Westchester. It's not that hard to find somebody with a house that's worth over $1,033,000. And if that's the case, the house, is going to potentially lose its exempt status. So you want to just be mindful of that. But again, if there's a spouse there are certain rules that kind of take you out of the exception. If there's a spouse, if you've got a minor child, or a child of any age that's blind or permanently disabled, you're not subjected to that. When does the house lose its exempt status? Well, if you move out. And if you move out, what does that mean? What if you go into a nursing home? So now you've left the house, you've gone into a nursing home. There's no spouse, right? A lot of the planning that we do is not necessarily for when the first person gets sick. It's for when the second person gets sick. When the first person gets sick, if a proper power of attorney has been prepared, we could take all the assets from the ill spouse and move them to the well spouse and do something called spousal refusal, and combine that with trust drafting and other things. But there's often a lot that we can do when the first person gets sick. Most of what we talk about, most of the planning techniques have to do with when there's only one person left. When there's a single individual, there's no spouse, you can't transfer the assets to the spouse. Because, by the way, that's an exempt transfer. Transfers between spouses are not subject to the 5-year look-back rules. It's an exempt transfer. So if you haven't done your planning, or if your clients haven't done their planning, and somebody goes into a nursing home, the house is going to lose its exempt status. Now, I underlined in my slide, without the intent to return home. So there's another, trick, right? Or loophole or planning technique, however you want to refer to it. If a person leaves their primary residence to go into a nursing home, we usually have them sign a statement of intent to return home. The statement of intent to return home is a subjective intent, right? And there's case law behind this. An individual that's entering into a nursing home can say, when I'm done rehabilitating, I'm going back to my primary residence. And if they do that, then Medicaid cannot treat the homestead as a primary residence, as an available resource. And so that's one way to keep the house out of reach from Medicaid, at least as a resource. We're going to talk a little bit later on about Medicaid's ability to put a lien against the property. But for purposes of initial Medicaid eligibility, the house will not be considered a resource if somebody signs a statement of intent to return home. Okay? And there's some exceptions to that as well. So how does somebody lose their property? So before I go to there's some questions. This homestead is different than the homestead exemption under the New York State debtor creditor law. I don't know the answer to that. I don't know much about New York State debtor creditor laws. Also, can the nursing home collect on the house with the homestead after? So we're going to talk about that, right? That gets into one of the later slides, and the answer is yes. And that's where some of the planning, really comes in handy. So how does one lose their property? How does Medicaid take the property? And so, I'm sort of going to answer your question right now. The first is that the house is considered an available resource, right? It becomes non-exempt property. So you left your primary residence, you went into a nursing home, there's no statement of intent to return home. It's an available resource. So that's unfortunate because of what I just said. There are things that you can do. But what about that vacation home, right? What about that secondary residence? What about that hunting lodge, that cabin, that, whatever you have upstate? That never was afforded any kind of protection, right? It's not your primary residence. We just went through that. That's why I thought it was important to kind of start from the beginning and take you through this. So if you, God forbid, have to go into a nursing home and you want to apply for Medicaid and you have a property down the Jersey Shore, well, you've got a problem. You got a problem. Now maybe we would transfer that property to your spouse, but what if there's no spouse, right? We got a problem. We're ineligible because we're over-resourced, right? So a lot of people that come to us, they say, well, Sal, why do I have to spend all this money on a trust, on this and that? I thought my house was an exempt asset. Well, now you can intelligently explain to them that it is initially, but there are a lot of things that can change that. And yes, you've got the benefit of your spouse right now, but what happens when one of you passes away? Oh, and by the way, what about your property down the Jersey Shore, right? So that's a good way of answering those questions when people think that they don't need to do the planning. But this sort of answers your question. We get into the liens and recoveries. Medicaid can place a lien against your property, even though it's your primary residence, and even though it's an exempt resource. So when I say exempt resource, I mean it's exempt for purposes of Medicaid eligibility. It's not exempt for purposes of liens and estate recovery, right? So, and now this really depends on what county in New York State you operate in, because every county sort of practices differently. The Department of Social Services sort of implements, these practices differently in every county. So let me take you through this, right? An individual client living in their primary residence under the home equity limitation goes into a nursing home. We file a statement of intent to return home. Medicaid says, okay, fine, you know what you're talking about, and we can't do anything about this house. We can't count it against you. And you've got no other assets in your name. So you're eligible for Medicaid. But we're going to place a lien against your primary residence. We're not going to count it against you. We're not taking it away from you right now. We're going to pay for your care, but we're going to put a lien against the property. And when the property obviously is sold, we're going to get paid back, for whatever benefits we properly paid on your behalf. And that's a real risk. That's real exposure. Now, do they always do that? No. Why? I haven't the slightest, foggiest idea. But they don't always put the lien. In some counties, they do always put the lien. So depending on what county you're in, you've got to be very careful because the lien is often placed. I had a very successful case once where somebody came to me and their mother was in a nursing home for, I think it was like 5-6 years. And you can only imagine how much Medicaid paid on that person's behalf. And they came to me, it actually came up in the context of a guardianship proceeding. I had commenced a guardianship proceeding for purposes of creating a revocable trust, which you'll see in a minute why that's important. She was on Medicaid in the nursing home, and I wanted to go to court. I wanted to set up a revocable trust, and I wanted to put the primary residence in the revocable trust. I show up to the guardianship part, and DSS shows up and says, "Hey, Sal, how you doing? Good. How's everything? How's the family? Good, good, good. Here's notice of the lien that we intend to file against the primary residence." I said, "Oh, that's nice." So I was sort of like kind of dead in the water. But there's a rule, right, in the regulations that says a lien must be vacated if the person comes home, even if the person comes home for a day. So what we did was we, engaged the geriatric care manager. We were able to put services in place, caregiver services in place. We took her home and they had to vacate the lien. They did. They vacated the lien. I continued with the guardianship proceeding. The court gave me permission to set up a revocable trust. I transferred the property to the revocable trust. I'm kind of letting the cat out of the bag. You're going to see in a minute why that's important, because we avoided probate. Luckily, and I think this is also just a good deed, the client passed away at home. When the client passed away at home, there was no lien against the property, and Medicaid could not come after the probate estate, or they couldn't come after the revocable trust because it was not part of the probate estate. And we avoided all recovery on behalf of Medicaid. So that was a great success story, but that really does happen. That really does happen often. And you want to be prepared to tell your client, maybe not the details of what I'm sharing with you right now, but you need to be knowledgeable enough to say to your clients, hey, listen, you got to be careful over here, right? You got to do something about this house because a lien could be placed on the house. By the way, a lien is prohibited where there's a spouse, a child on the age of 21. You could see from the slide all the the exceptions to placing a lien, right? And then just what I had mentioned before, Medicaid can only file a claim against the probate estate. So you've got liens, and then you've got estate recovery, and the estate recovery can only happen against the probate estate. So avoiding probate, perhaps by using even a revocable trust, right? We're going to talk about an irrevocable trust as an advanced planning technique, but even a revocable trust could be very useful because it avoids probate. And the statute, the regulation says that Medicaid can only file a claim against the probate estate. And so this is the practice. This is elder law, right? Navigating these waters. They're very complicated. They're very technical. And you've got to kind of go in and out of all these different, statutes and say, what can I do? What can I do? And it's like a jigsaw puzzle. So what about assisted living? If both spouses go in, one spouse is really going into assisted living. I'm not sure what the question is. All I could say is, Randy, that Medicaid doesn't generally does not pay for assisted living. If one spouse goes into an assisted living and the other one needs to go into a nursing home, then I would probably use the spouse that's going into the assisted living as the receptacle for transferring assets to, doing spousal refusal, things like that. But Medicaid doesn't pay for assisted living. So that's something that you should be aware of. And the next question is, can they place a lien on a multifamily home with other owners? They can, but they can only lien the ownership of the Medicaid applicant. So if there are three people that own the multifamily home, the lien can only be placed against the interest of the person that's on Medicaid. There are other arguments that could be made to try to take that multifamily home off, out of the equation. For instance, one of the exceptions to an asset being considered an available resource is that there might be a legal impediment, right? Again, these are great ideas, and there's fair hearings on this, but it's a fact by fact, circumstance, if you would. So I can never tell you it's absolutely going to work. But sometimes, we've been successful going in there and saying, hey, listen, you've got three owners, and these other two guys, they're not going to sell the property, and they're not signing anything, they're not selling. So there's no way you're never going to get your interest in the property. I guess they could bring a partition proceeding if they really wanted to, but it's Medicaid. I'm not sure I've ever seen that. And sometimes you can get the asset to be considered an unavailable resource by virtue of a legal impediment. So I don't know. So what do we do? Now, we've got the background, right? We've got a client that comes to us. You broke them down like law school, right? Every client, I shouldn't say every client, but many clients come here and they want to tell me what they want to do, and they're in control, and they're not giving up control of their house. And so you got to sometimes break them down and kind of build them back up, just like they did to us in law school. And you do that by educating them, right? Being empathetic, right? Because look, this is scary. This is stressful. You're talking to somebody about their house. They've worked their whole entire life to have this house. Maybe in some cases it was passed on through generations. So you don't just want to come in there and just dismiss people's, feelings and what they may think. And unfortunately, a lot of times what they think is based on what they heard, and what they heard is 99% of the time incorrect. So you just got to be empathetic, and you kind of like, that's part of being an elder law attorney, and you got to work through all that and make somebody feel comfortable. It's not always possible, but hopefully you can do that. And if you can, they're now willing to listen. And they say to you, okay, Sal, I get it. You told me that the house is not an available resource, but that they could put a lien against it. And what happens if my spouse dies? This is all in my head, and I don't want to. Just tell me what to do. What can we do? All right. Well, the first thing is, you might be presented with a case where somebody came to you too late, right? And a lot of times you're representing the children. Maybe you're doing real estate closings for the children, and they're telling you about their parents, or they're calling you up because you've got the close confidential relationship with the family. That's why I get a lot of referrals from real estate attorneys, because I bet you've got great relationships with those that you represent. You're in the local community, you're in the town. People call you first. The hope for me is that you've got enough knowledge to be able to say, hey, wait a minute. I've got an idea of what's going on over here, but we need to further explore this. We need to, talk to somebody else. You're going to see later on in one of my last slides, I say you don't get a second bite at the apple sometimes, and that's for real. When we start talking about the trust, if it's drafted improperly, you could really cause some problems. But you might have a child that calls you up and says, hey, listen, you're not going to believe what happened. My mom was sitting at the dinner table. She had a stroke. She's going into a nursing home. I don't know what to do. Well, one of the first thing that you want to do is start assessing. And remember, we're just talking about the homestead now. We're not talking about, Medicaid and this and that. You want to assess if there's any low-hanging fruit, right? And exempt transfers of the homestead are low-hanging fruit, right? So you can transfer the house, like I said before, to a spouse. But what if there is no spouse? Well, we've got these other exemptions. And I'm going to skip to the two that are most popular, right? A caretaker child, right? But again, be careful. Read this. An exempt transfer to a caretaker child only exists if the child was living in that homestead for the 2-year period immediately prior to the parent going into a nursing home. That's what we mean by institutionalized care, right? And who provided care to the applicant, keeping that person out of the nursing home for that period. So Medicaid is starting to ask for affidavits, prove to us that you live there. So, utility bills, driver's license, things like that. And depending on the caseworker, affidavits getting into the details of the type of care that you provided. So you got to be careful. Like I've seen attorneys, non-elder law attorneys, just go off and just draft a deed to a child, thinking that a child is a caretaker child, and the child doesn't fit the definition, right? So for instance, also, you're not going to transfer title to a child years in advance under the theory that the child is a caretaker child. For instance, what if the child moves out? What if the child dies, right? You don't know if you have a caretaker child until the parent goes into the nursing home, because it's the 2 years immediately prior to that entry. So it's a last minute planning technique. It's not something you do in advance, right? And I've seen that happen before. I've seen deeds transferred to children who are no longer, or maybe they thought they would be, but they didn't maintain that status. And now all you have is just an outright non-exempt transfer, which is not a good idea. And then the other one are transfers to siblings with equity interest. That's, you don't see that too often, but it's a good one if you're knowledgeable, and you could tell somebody, hey, listen, your brother, your sister, they've been living there. They have an equity interest. Let's transfer your interest to them. That's a good one, right? And the other, so those are all statutory, exempt transfers. But I thought I'd throw it in there, and I've been talking about this a little bit, but a revocable trust, right? So what if I have somebody that never did their planning, they never went to see an elder law attorney, and they get sick and they go into a nursing home? Well, remember the case I was telling you about before. Assuming that person has capacity, right? In my case, I had to go to court to get the guardianship part to allow me to do this. And this is also why you want to have a power of attorney that's been properly modified by an elder attorney. I have to say, one of the biggest problems that I see out there are powers of attorney that are drafted by non-elder law attorneys. The basic form is really no good. It's good for what it's worth. It's good for check writing. It's good. You guys see it all the time for selling the property. But as far as estate planning and elder law, it's absolutely useless. We've got to modify that power of attorney. We throw in so many modifications, and a lot of them that the clients might not ever use or ever need. But one of them is the power to create a trust and to fund the trust. So if somebody goes into a nursing home and they haven't done any of their planning, even at the last minute, we could transfer the property to a revocable trust. And if we get lucky and Medicaid doesn't place a lien against the property, because they still can place the lien, even though you're putting it in a rev trust, they could still place the lien. But even if they don't, if we get lucky and they don't, then we've avoided the estate recovery. And I can't tell you how often that happens. I'm not sure I understand the rhyme or reason behind the Department of Social Services, but they don't always put the lien. So even at the last minute, we could scrape the bottom of the barrel and we could potentially avoid recovery. So always think about a revocable trust when somebody hasn't done their planning. But now we get into like the three major techniques, right? And I'd like to do this real quick, just summarize them. We've got outright transfers, life estates, and Medicaid trust, right? Those are the three things that we're going to spend the remaining portion of our time talking about, right? But generally speaking, those are the three most popular planning techniques. Rick, I see your question. I think it's going to get answered in this. So an outright transfer, least favorable technique, right? Now we're going to talk about taxes and we're going to get real excited now. So least favorable technique. Why? You take somebody's property and you transfer it to their kids. You've lost almost everything, right? You lost the opportunity to receive a step up in basis upon the death of the parents, right? It's a carryover basis. So that example I gave before of the clients that bought a piece of property many years ago for $25,000, and now it's worth $750,000, and they gave it to their kids. Well, now to the kids, it's worth $25,000. Obviously, the basis can get adjusted for improvements and things like that. But you just took a $25,000 basis and gave it to the kids. And I see this all the time. So I sometimes am a little bit more reserved. I'm like, everybody already knows this. But everybody doesn't already know this. I see it happening all the time. Clients walk into your office, it's about time we do something with the house. Let's give it to our kids. Okay, I'll do a deed, draft it to the kids. No, right? And they're going to lose their tax exemptions and their real estate deductions, right? And this is where they really lose control, right? So you hear all those horror stories. People come in all the time and say, my kids are going to kick me out of my house. Well, if you do it the right way, your kids aren't going to kick you out of your house. But if you do it like this, the kids can kick you out of your house, right? The kids own the property. And I've seen situations where parents have transferred assets to kids, and then the kids get divorced and they die. And you've got those issues now. You took your asset and you gave it to somebody else, and it's subject to all of their issues, right? So it's the least. I rarely do outright transfers, rarely. But in some cases we may, right? So what did I say at the bottom over here? May be considered where property is earmarked for a specific beneficiary. I'll give you an example later on. And there's very little gain, right? Maybe the house was just purchased not too long ago. Or maybe a spouse already died and there's a partial step up in basis. Or maybe it's not the primary residence, so we don't care about tax exemptions or real estate deductions. So I had a case where there was an upstate property. It was like a camp, and it was going to the son, not the daughter, not anybody else. It was going to the son. The son was already living there. The son was the one that was, using and benefiting from the property for all these years. And it was understood in the whole entire family that was the son's property. And there was a partial step up in basis, right? So there wasn't much of and the fair market value and the cost basis, there wasn't a big discrepancy. And so we transferred it to the son because we really weren't losing out on anything. When we do these things, though, there's a little bit of a tax technique, right? Where I don't want to retain a life estate, which we're going to talk about a life estate in a minute. And in this particular case that I'm mentioning to you, I didn't want to retain a life estate. I didn't need to retain a life estate. I still wanted to try to get a step up in basis. So what I did was I put in the deed a power of appointment. And a power of appointment is a retained interest for tax purposes. And so when this particular client of mine dies, there's going to be a step up in basis, for the outright transfer. I didn't want to use a life estate. I didn't need to preserve tax exemptions or anything like that. And I didn't want to use a life estate because just in case the son decides to sell the property, I don't want any money going back to my life tenant, right? So there are instances where I don't want to use a life estate. In most cases, I want to use a trust. But if I have to consider an outright transfer, I don't want to just arbitrarily throw a life estate into the deed because I just may not need it. And I want to think about what happens in the future. So let's go into life estates, right? Life estates, and you're going to see one of the biggest problems with a life estate are the adverse tax consequences when that property is sold. So life estates were really popular prior to the Deficit Reduction Act of 2005. After the Deficit Reduction Act of 2005, Medicaid trust, the irrevocable trust, became the popular, planning technique. Why? Because back then, the look-back period was only 3 years for a life estate deed. It was 5 years for a trust, but for outright transfers or life estate deeds, it was 3 years. So a lot of people would come into the office and they would say, listen, I'm not spending all this money on a trust. And by the way, I don't like this 5-year look-back period. Maybe I'm already in my 70s or 80s, or maybe I'm frail, whatever the case. And I'll do the life estate. Now, what do they always say to you? And I'm never going to sell the property. Okay, so we would draft life estates, right? And if I draft a life estate, I always put a power of appointment in the life estate deed so the client retains the power to change the beneficiaries. I've had to use that many times, right? So once the Deficit Reduction Act of 2005 came along, it's a 5-year look-back period for everything. So why would you do a life estate that has all these adverse tax consequences associated with it, as opposed to a Medicaid trust when you've got the same 5-year look-back period? And as you'll see with a Medicaid trust, the flexibility is off the charts. You could draft that trust, and as long as you don't run afoul of the Medicaid laws, you could provide so much flexibility to the clients, right? So the life estate really became less popular, right? So we don't use a life estate on a regular basis, but when I do use a life estate, we do combine it with a limited power of appointment. What are the more common instances when we use a life estate? Remember those exempt transfers I was telling you about? If I'm going to make a transfer to a caretaker child, if I'm going to make a transfer to a sibling with an equity interest, and other cases, we might still use a life estate, right? But the big problem with a life estate is if it's a big if, and I know the clients tell you they're not going to sell, but if that property is sold during the client's lifetime, then there are adverse tax consequences to the kids, the remainderment on the deed. So a portion of the proceeds have to go back to the parents, number one, because they're life tenants and they're entitled to receive a portion of the proceeds. And a portion of the proceeds go to the kids. And then the capital gain has to be calculated on both of those interests. And so the parents can actually exclude their gain because of the $250,000, $500,000 exemption under the Internal Revenue Code. The kids don't meet that Section 121 exclusion, right? It's not their primary residence usually. They haven't been occupying the property for 2 out of the last 5 years. So you end up with a situation where you've got like a double whammy over here. Money goes back to the parents who could potentially be facing or in a nursing home, right? I can tell you how this comes up. And the kids are going to be paying capital gains. So this usually comes up because the house is an exempt asset, right? Because it's a life estate. And the kids, after the parents go into the nursing home and apply for Medicaid and get Medicaid, the kids say, how are we going to pay for this house? Nobody's got money to pay for the real estate taxes, the utilities, whatever the case may be. Because my advice to them is hold on to this until your parents die. And, it could be a case where they just don't have the wherewithal. It could be a case where the parents could be in a nursing home for a long period of time. And the kids just come together and they say, we have to sell this property. And that's how you end up having to sell a life estate. There are other instances where, the parents on their own just want to sell the house and downsize. It's coming up frequently. I did 3. So people usually call me to do the calculation and then do the tax returns. And I did 3 of them last year, which may not sound like a lot, but it actually is. And I also received 2 phone calls last year because I presented on this to the New York State Bar Association, and they put my presentation on the internet, and 2 people from across the country called me on it. It comes up often. And I wanted to just share with you, and I've given this to you in your material.
Hey, Sal, before we go to the next thing, can we give the course code?
Yes, the course code is Ironman.
Thank you.
I just wanted to share the my PDF on the closing statement for well, that doesn't do it. Did you see that, Diana?
Yes, we can see it.
Okay. So I've given this to you guys. I've lectured on this before, I think, for a judicial title. This is my closing statement. I'm not a real estate attorney, by the way. I don't do real estate closings. But this is my form of a closing statement that I use when somebody, usually a real estate attorney, calls me up and says, hey, we're doing this transaction and it's a life estate. And I just found out that we've got to allocate this and I have no friggin' idea what I'm talking about. Could you help? And that's honestly how the call usually comes in. So make sure you take a look at that deed, because the language for the life estate is buried usually. It's somewhere in the middle of the deed. And it's overlooked often. A lot of times these calls come to me when you're very close to a closing table. But here's the gist of it. I'm not going to go through this whole thing with you, but if you look over here where it says relevant factors, you've got to obtain these, right? So this is from 2022, but you've got to get the 75/20 rate and the age of the life tenant. And then you go into what we call table S. It's an IRS table and you find these values, right? And this is what's very important, right? And so depending on what the 75/20 rate is and the age, these values change. And then what you do is you just carry that through, right? And so you do your regular closing statement, however you like to do your closing statement. But everything gets allocated based on these percentages, right? So the proceeds get paid out. Here's the life tenant, obviously, here are the remainder benefit. And this was a case, again, where there were 3 kids and they didn't want to pay for the house, the upkeep and the maintenance, right? So they wanted to sell, right? And that's usually what you see, right? So here's the life tenant and here are the remainder beneficiaries. So you start allocating, the proceeds, et cetera, and then you calculate the capital gain. So you allocate the cost basis the same way, right? So here's my cost basis, and then I apportion it, right, among the remainder beneficiaries. I didn't really care about the life tenant because I knew he wasn't paying any taxes. So ultimately what you do is you allocate the proceeds and the capital gain out to the remainder beneficiaries. And this is what shows up on their tax return. And so you got to tell these people that they've got to make estimated tax payments, because otherwise next year when they do the tax return, they're going to have $131,000 capital gain and they didn't make any estimated tax payments. And you can imagine what that's going to look like. And what about if you've got an out-of-state seller, right? So these are all the different things that you've got to pay attention to. But I think that's a really, really good, spreadsheet. You should use it. Back to my slideshow, right? So now we're talking about Medicaid trust. Medicaid trust, which is like our bread and butter, right? Most flexible planning technique, right? One of the big things with a Medicaid trust is that if you put the property, any property, whether it's your primary residence or another piece of property, you put those properties into the Medicaid trust, they could be sold at any time. And because the trust is drafted as what we call a grantor trust, we're only looking at the parents. And so the parents can exclude $250,000 if it's a single individual, or $500 as a married couple. So you put the primary residence into the Medicaid trust. Nothing goes back to the kids. The kids don't pay any capital gains tax. It's all allocated back to the parents, but they can exclude $500,000 if it's a couple. So nearly that entire gain, like if you, I already took it off the screen, but if you go back to my my spreadsheet that I gave you, if all of that gain was allocated back to the parents, it would be covered under the $500,000 exclusion, right? And there'd be no capital gains tax. So the Medicaid trust is huge from that perspective. And on top of that, if the property is sold, none of the money goes back to the parents. So not only the taxes, right, but no money goes back to the parents. With a life estate, this is why we don't like life estates most of the time. If the life estate is sold, not only do you have a tax issue to the kids, but you've got money going back to the parent who may be in a nursing home. So guess where that money's going? If the parent's already in a nursing home, that money's going to the nursing home, right? The Medicaid trust stops all that from happening. And it's the same 5-year look-back period, right? And you've got a tremendous amount of flexibility in the way you draft the trust, right? You could provide, for instance, rental property. I can make it so that way the income goes to the kids. I don't have to have the rental income coming back to the parents. Maybe they don't need the rental income, right? With a life estate, the rental income is going back to the parents, right? The life tenant is entitled to all of that. With a Medicaid trust, I can draft it so that way the parents don't get the income. The income could be, distributed to the kids, right? And you take away so many of those issues, especially with an outright transfer, right? The trust does not subject you to the creditors of your children. What if your kids get divorced? What if they die? Well, by the way, the trust is drafted to say what happens if a child dies, and if a child's going through a divorce or has creditor problems, or what if you just don't get along with your kids anymore? Well, we put powers of appointment in the trust to change all of that. Right, that's also in a life estate deed, and it could be in an outright transfer, but it's also in the Medicaid trust. So there's so many different things that we can do with a Medicaid trust that just makes it the more optimal planning technique. Beware, and this I said it, and I'm being explicit about this. The Department of Social Services is constantly looking to attack these trusts. It is not a type of trust where you're just going to go grab a form. You don't do that. Please don't do that. It's riddled with tax matters. And recently, I used to tell people, be careful about drafting these trusts because you don't want the trust to be considered an available resource. Because if you do something incorrectly, if you say something incorrectly, and Medicaid looks at this trust and says, no, we're going to treat that as being within the dominion control of the creator, and so therefore we're coming after the house, then you might be screwed, right? And just recently this year, the Department of Social Services tried to do that in a very esoteric way by arguing that if the trustee had the power, I mean, this is how specific this gets and how technical. If the trustee had the power to make capital improvements to the property of the trust, then the creator of the trust was receiving a benefit from the trust. And under the Medicaid laws, the creator cannot receive any benefits from the trust. So therefore, the trust is considered an available resource. Makes no sense, absolutely no sense. And thank God we've got some very competent colleagues in the elder law section that were able to defeat this. But this is the direction that the Department of Social Services is going. This is the department of that Medicaid is going. They're trying to attack these. And if you say the wrong thing in these trusts, you can upset the entire trust. And then, because of the irrevocable aspect, if you don't have the right language and they're allowing you to either decant or amend under using the New York State statutes, you're really screwed. I've had many cases come to my office, trusts that were drafted by non-elder law attorneys, and I was stuck. I was dead in the water. I could not do anything. And clients obviously don't want to hear that. And that becomes a problem then, because then when you go into the nursing home and you can't apply for Medicaid, then the nursing home is sending you an $18,000 a month bill. And you can imagine what that looks like. So please be careful with these trusts. Because most of your clients need them, right? The one thing about this area of practice is that a good portion of the people that are walking around the streets need this type of planning. So you've got the opportunity to have serious discussions with your clients. And if you do, I just want you to be knowledgeable that these are the pitfalls that you should be aware of. Let's see if we can answer some questions real quick. I don't know. Kathy, I just asked a question about adding powers of appointment to the deed, but put in the chat. I don't know where it is, Kathy. Let's see.
Sure. Do you want me to read it to you?
With regard to adding the power of appointment to a deed, does this interfere with transferring title after death? So, Kathy, I'll invite you to reading my article from like 15 years ago for Chicago Title. I think it was called something about powers of appointment between a rock and a hard place. The title companies, matter of fact, there was a gentleman by the name of Lipschitz. I didn't know him personally, but my partners, brought into my attention. He wrote extensively on this issue. It should not interfere with transferring title after death, but the title company does sometimes ask for, affidavits from the remainder beneficiaries, stating that to the best of their knowledge, they don't know of the exercise of this power of appointment. But it is an interesting issue where it's sometimes impossible to prove to a title company whether the creator exercised the power of appointment. But I did write an article about that years and years ago, and I think it's on my website, Plan Today for Tomorrow. And you could also email me and I could send it to you. I think I still have it someplace. The life estate. So Tom, we're often very blunt with our clients. If you're concerned about legal fees, you're in the wrong ballpark. The life estate is not favored over the trust because of the legal fees. And I will not generally defer to a client that's not willing to pay the extra fees for a superior planning technique. I might just refuse to represent the client, right? Because we feel, it's that much of a better planning technique. So I'm not going to just prepare a life estate because a client doesn't want to pay for the trust. That's my practice. That's my personal opinion, but they're asking me to put forth an inferior planning technique and it's against my better judgment. So I think that's a proper way to proceed. So I think that's it for the questions. Elaborate on what limited power appointment looks like? It's a paragraph that just usually says that the creator retains the right to change the beneficiaries of the trust, there are different types of powers of appointment, right? There are general powers of appointment. There are limited powers of appointment. So you got to be careful at how you word these documents, because you could have tax issues. Now, in a Medicaid trust, we're not concerned about estate tax inclusion because we want it to be includable in the estate of the creator. If somebody's got an estate tax, we're generally not using doing Medicaid planning. If the house is put into the trust and the trustee dies, do the children have to redeed? No. The title is in the trust. It's in the name of the trustee. If that trustee dies, as a successor trustee. So no. Okay, Diana, I think I'm 1 minute over, but I did the best that I could.
Thank you, Sal. You're always engaging, always interesting topic. Thank you so much for doing the CLE. Everyone, I will resend you all the materials this afternoon, just in case you missed anyone. And I want to wish everyone a happy holiday and a happy new year. And we will see you in the new year. Thanks again, Sal, and thanks everyone for coming.
Happy holidays to everyone. Yes.